The Road Traffic Act, Part 4, reckless, dangerous and careless driving. Section 58, reckless or dangerous driving. Subsection 1. A person shall not drive a motor vehicle on a road recklessly or dangerously or without due regard for the safety of other persons or property. Subsection 2. In considering whether subsection 1 has been contravened, the court shall have regards to all circumstances of the case, including the nature, condition, and use of the road upon which the contravention is alleged to have been committed, and B. the amount of traffic which at the relevant time was or that could reasonably have been expected to be upon that road. So here the court would consider the road conditions and the traffic conditions of the road if you're going to be charged with reckless or dangerous driving. Among other conditions. But anyway, we continue. Subsection 3. A person who contravenes subsection 1 commits an offense. Subsection 4. The court shall order particulars of any conviction for an offense under subsection 3 to be endorsed on the driver's license held by the person convicted. Subsection 5. On a second or subsequent conviction for an offense. So subsection 4 says they're going to make a record of your offense. Now subsection 5. On a second or subsequent conviction for an offense under subsection 3, that is second, third, fourth, fifth, and so on, the court shall order that the offender be disqualified from holding or obtaining a driver's license unless the court, having regard to the lapse of time since the date of the last conviction or for any other special reason, thinks fit to order otherwise. Subsection 6. Subsection 5 shall not be construed as affecting the right of the court to exercise the power conferred by that subsection on a first conviction. So they may very well suspend your license on the first conviction if the court sees fit. Alright. Subsection 7. Where a person is convicted of aiding, abetting, counseling, procuring, or inciting the commission of an offense under this act, and it is proved that he was present in the motor vehicle at the time of the commission of the offense, the offense of which he is convicted shall, for the purposes of the provisions of Part 4, relating to disqualification from holding or obtaining driver's license, be deemed to be an offense within the meaning of Section 35. Right now we're at Section 58. Okay, in the meaning of Section 35. Subsection 59. No, Section 59, careless driving. Subsection 1. Subject to subsection 2, a person who drives a motor vehicle on a road without due care and attention or without reasonable consideration for other persons using the road commits an offense, whether or not such driving results in a collision with a pedestrian, another vehicle, or with property. Okay, so even if your careless driving does not result in an accident, you can still be prosecuted for it. Subsection 2. A first or second conviction for an offence under this section shall not render the offender liable to be disqualified from holding or obtaining a driver's license. Section 60. Causing death by reckless or dangerous driving. A person commits an offense if the person causes the death of another person by the driving of a motor vehicle on a road recklessly or at a speed or in a manner which is dangerous to the public, having regard to all circumstances of the case, including a. the nature, condition, and use of the road. So the court will consider that. Also, B. the amount of traffic which is actually at the time or which might reasonably be expected to be on the road. So I guess they might not be able to determine the traffic at the time, but they could reasonably say what level of traffic would be on the road at that time. C. the speed and manner in which the motor vehicle was driven. Section 61. Power to proceed on charge of reckless or dangerous driving on hearing of charge of manslaughter. Subsection 1. Upon the trial of a person who is indicted for manslaughter in connection with the driving of a motor vehicle by him, it shall be lawful for the court, if the court is satisfied that the person is guilty of an offense committed under Section 58, to find him guilty of that offense, whether or not the requirements of Section 65 have been satisfied in respect of that offense. Right? We haven't read 65 yet. We'll see what Section 65 says when we reach there. Subsection 2. A person who is charged with an offense under Section 63 who causes the death of another person may be convicted of reckless or dangerous driving under Section 58. Section 62. Power to proceed on charge for careless driving on hearing of charge for reckless or dangerous driving. Subsection 1. Subsections 2 and 3 shall apply where a person is charged before a court of summary jurisdiction with an offense under Section 58, and the court is of the opinion that the offense is not proved. Let's look back at Section 58. Remember what Section 58 says. Person shall not drive a motor vehicle on a road recklessly or carelessly, or dangerously, or without due regard for the safety of other persons or property. Alright. So, we're at Section, what's it again? Section 61. Upon the trial of a person, power to proceed on charge of reckless or dangerous driving on hearing of charge of manslaughter. Oh, we read 61 already. It's now Section 62. Power to proceed on charge for careless driving on hearing of charge for reckless or dangerous driving. Subsection 1. Subsections 2 and 3 shall apply where a person is charged before a court of summary jurisdiction with an offense under Section 68, and the court is of the opinion that the offense is not proved. So the offense is not proved. 2 and 3 shall apply where a person is charged before a court with an offense And the court says the opinion is not proved. Let's look at what subsections 2 and 3 says. Subsection 2. The court may, at any time during the hearing or immediately after the hearing, without prejudice to any other powers possessed by the court, direct to allow a charge for an offense under section 59, which is careless driving, to be preferred forthwith against the accused person, and thereupon proceed with that charge. So here it says, with an offense is charged before a court with an offense under section 58, and the court is of the opinion that that offense is not proved, but this says the court can still charge you with careless driving. Subsection 3. Where the court takes action under subsection 2, the accused person or his attorney at law shall be informed of the new charge and be given an opportunity, whether by way of cross-examining or any witness whose evidence has already been given against the accused person, or otherwise of answering the new charge. Okay, so that's the new charge of careless driving, I guess, instead of reckless or dangerous driving. B. The court shall adjourn the hearing if it considers that the accused person is prejudiced in his defense by reason of the new charge being so preferred. Subsection 4. Every accused person in whose case the requirements of section 65, that's the restrictions on prosecution, has been satisfied. We haven't reached 65 yet though. Or do not apply as respect the alleged offense under section 58, may be convicted on a charge preferred under subsection 1. Nonetheless, that thus such requirements have not been satisfied as respects the alleged offense under section 59. Section 63. Disqualification for offenses causing death. Subsection 1. A person convicted of manslaughter in connection with the driving of a motor vehicle by him, or an offense under section 60, shall, unless the court, for special reasons, thinks fit to order otherwise, that person shall be disqualified for holding or obtaining a driver's license for a period of 12 months from the date of conviction, or for such longer period as the court thinks fit. Alright. So, convicted of manslaughter, your license, driver's license, will be suspended for a year. Alright, subsection 2. Where a person is convicted of aiding, abetting, counseling, procuring, or inciting the commission of an offense referred to in subsection 1, and it is proved that the person was present in the motor vehicle at the time of the commission of the offense, that means the person is a passenger, right? Boosting, encouraging the driver to drive recklessly. Alright. The provisions of subsection 1 shall apply in relation to the offense of which he is convicted, as if it were mentioned in that subsection. Section 64. We will look at this section in our next video.